Hello everyone, a very warm welcome to this week's session of the Global Youth Climate Training Program. And good morning, good afternoon, good evening, wherever you're based. My name is Lydia and I will be your co-moderator for this session. So today we'll be learning more about climate litigation. We have been seeing a growing movement of climate litigation and studies that show this growing trend. So it is becoming increasingly relevant topic and also a very important tool for climate justice.
Indeed, Lydia, and we're so lucky to have some of the best guides who can speak to this very important tool in the toolkit of climate justice. My name is Alexis McGivern. I work at Oxford Net Zero, and I'm going to be co-facilitating with Lydia today. And we're really grateful to be joined today by folks who not only have really deep expertise, but also lived experience in the weeds of climate litigation. We cannot wait to hear more from them in the session. So I wanted to start by having this case that happened in Montana very recently, which is a judge who heard the first ever constitutional climate trial earlier this year, has actually ruled in favor of a group of young plaintiffs who had said that state officials in Montana had violated their right to a healthy environment. So we thought this was a really good way to start the session of reminding ourselves that there's actually growing trends in climate litigation that seem to be coming down in the favor of young people. Yes, so we're really lucky to... Sorry, go ahead.
Sorry. Yeah, and as always, we want to hear more about your learning journey, and we're always very curious to see your feedback and thoughts after the session. So please feel free to use the following hashtags to share your experiences. Back to you,
Thanks.
Alex.
Thanks so much, Lydia. So yes, these are our moderators for the session. We're really happy to be here with you. And this is our agenda for the session today. This is our agenda for the session. We have our first speaker, Mrinalini Shinde, who's going to be speaking to us about climate litigation, who has a wealth of experience in this field. We're excited to hear from her. We'll have a short Q&A from her. And then we'll be hearing from our second speakers from the People's Health Tribunal, Dr. Rhiannon Osborne and Ken Heshaw from We the People Nigeria. Then we have a break and a short interactive activity. And then we have our third speaker, Trina Chiemi from FACE, which stands for, stands for the Fast Action on Climate to Ensure Intergenerational Justice. So we're really looking forward to hearing from all our speakers today. And so today, as we did last week, we want to take some collaborative notes together. So we'll ask you to scan the QR code, and we'll also be putting the link to the document in the chat. And we can take collaborative notes together from the speakers on what your key takeaways are from each of them during the session. So we'll be sharing that in the session in the YouTube channel just now. Great. So without further ado, we're really excited to hear from Mrinalini Shinde, who just has so much experience in this field. She's an environmental lawyer and a researcher based in Germany. And she is currently a lecturer of international environmental law at the University of Cologne and is affiliated with Ingenios, which is the Indo-German network interaction of scientists at the Environmental Law Center of the University of Cologne. We wanted to invite her to speak because her previous role was as a fellow of legal affairs at the division of the UNFCCC Secretariat in intergovernmental matters, treaty implementation, and capacity building. She has previously litigated cases in environmental and criminal law and also advises the climate media nonprofit Climate Tracker Inc. as a policy associate. She's very busy because she's currently a candidate for the Joint Doctor of Laws at the Faculty of Law in the University of Cologne and at the University of Paris, Sorbonne. She holds an LLM in legal theory from Goethe University in Frankfurt and an MSc in environmental sciences from the University of Cologne and a BA from the National Law School of India University in Bangalore. So we're excited to hear more about her research on climate change, corporate environmental crime, and environmental criminal law. So without further ado, over to you, Mrinalini.
Thank you so much, Alex, for that warm invitation. I'm very happy to be here. And I want today's session to be a brief introduction to the obligations under the Paris Agreement that can lead to avenues for climate litigation. So it's not strictly a session on climate litigation. I'm sure that other speakers will delve further into specific cases of climate litigation, but I want to set the tone for what the Paris Agreement allows us to dream of. So let me just share my screen. Yes. And so I'm going to be focusing on the role of civil society and climate litigation in the context of international law. And in international law, I want us to look at both international civil law, in a sense, so which is the Paris Agreement, as well as the Rome Statute, which is the criminal international legal statute, because there is a current proposal to criminalize the crime of ecocide, which might lead to possible avenues that can lead to climate litigation domestically as well, criminal corporate litigation, for instance. And that is also something I want to discuss that about the possibilities that we can have in the future. So first, let's focus on the Paris Agreement, okay? So I am a fan of the Paris Agreement in the sense that it does try to envision a lower global temperature, and it has managed to cover several types of topics and substantive areas where climate action is required. So in that sense, it is a very strong collective dream that we tried to draft in the Paris Agreement. But as we know, a lot of further work is required to realize that dream in terms of implementation. And what the Paris Agreement created is obligations for its parties, right? Now, even though the Paris Agreement is an agreement between nations, there is a very strong element of civil society and people that is at the heart of the Paris Agreement. So the preamble itself focuses on the human rights and how the Paris Agreement acknowledges that climate change is a common concern of humankind, and parties should ideally take action to address climate change, while also respecting and promoting and considering their respective obligations on human rights. So there is a linkage between local communities, indigenous peoples, migrants, children. And so all of the previously marginalized communities within human rights law also find space within the Paris Agreement. And why I mention this is an attempt of the drafters of the Paris Agreement to make this a people's agreement in a way and we've seen so many people seize that opportunity in the past 7 years since the Paris Agreement came into force. So we are seeing the Fridays for Future movement with children. We're also seeing, scientists for future. We're seeing different parts of civil society stake claim to the Paris Agreement. And I feel that is because it has been designed in a way to keep people at its center and as its focus, even though it is, in the end, an agreement between parties, which is nation states. So keeping that in mind, how do citizens or regular people that the agreement mentions, how do you interact with the Paris Agreement? So the first is the objective that we are trying to achieve. Now, I'm sure you may have come across this already, but I wanted to quickly recap that the first goal is to hold the increase in the global average temperature to well below 2 degrees and to pursue efforts to 1.5 degrees. We also have to increase the ability to adapt to the adverse impacts of climate change. And we have to make finance flows consistent with the pathway towards low GHG emissions. And all of this has to reflect equity and the principle of CBDRC in the light of different national circumstances. So this is the goal of the Paris Agreement in its entirety, right? Now, this is what allows citizens to keep a check and to monitor whether or not their elected representatives or their governments are attempting to achieve those goals. Okay, having this target in this form allows us to have a benchmark by which to judge the performance of our governments. How they do that is also through the submission of nationally determined contributions under the Paris Agreement. So Article 4 explains how parties are supposed to prepare, communicate, and maintain NDCs, the nationally determined contribution, that details the domestic mitigation measures and also contains information on their highest possible ambition in light of CBDR. And there is an element of accounting. So parties are required to account for their greenhouse gas emissions, the anthropogenic ones. And this is based on integrity, transparency, accuracy. And this is important because this makes your governments obligated to submit information, and information is what drives litigation. So as someone who has been part of both the international law side in the past and as well as being a civil society lawyer, both sides of litigation work depend very, very heavily on access to information. Now, of course, at the international law side, there's not litigation per se at the work that I did, but we are always working with having access to the best possible information. So the obligation under Article 4 for countries to submit information on their GHG emissions based on those accounting standards is what enables civil society to maintain a check on environmental performance. Okay. So, for example, you have an excellent non-profit organization, Climate Action Tracker, which maintains the warming projection. So this is their update from November 2022, and they usually tend to update it before each year's COP. And so this was the one they did before last year's COP. And you can see that there is a very clear discrepancy between the NDCs that have been pledged by parties and the actual real life policies and actions. So we are currently slightly below 1.5 degrees goal. So remember that the Paris Agreement wants us to pursue efforts to limit it to 1.5. So we are very, very dangerously close to exceeding that limit. But the hard goal of the Paris Agreement is to limit it to under 2 degrees. So if you look at the current policies and actions that based on real world action, if you take an average of the best case scenario and the worst case scenario, you reach somewhere around 2.7 degrees, which is 0.7 degrees above the goal of the Paris Agreement, which is extremely concerning. And the best case scenario, based on what has been claimed in NDC targets, is around 2 degrees Celsius. So the pledges and targets in its best case scenario are achieving the Paris Agreement goals. But this is extremely tenuous because the real world action does not comprehend. So you see how having access to this information allows civil society to create awareness and hold parties accountable. Okay. And here you can also see the emission gap that was created by Climate Action Tracker in November 2022 as to the difference between the pledges and targets as well as the policies and actions. And then they also show what is required in terms of meeting that gap in order to be compatible with the Paris Agreement, which is a very significant gap, as you can see, in terms of emissions. Okay, so this was just to show you the advantages of having access to information that is demanded by the Paris Agreement. Okay, now, if you are new to the Paris Agreement or the UNFCCC, you need to be familiar with the different levels of obligation. So in international law, usually shall or must implies that whatever follows that operative word is binding and mandatory. Whereas you see softer obligations, which are more voluntary, preceded by words such as should and encouraged, etc. And there is a lot of descriptive non-law. For example, in the preamble, you will see a description of the current situation, the need to have the law in the first place. This is descriptive and it adds value and provides context to the legal parts of it, which are the should and shall obligations, okay? With shall being the most mandatory. Then, in the Paris Agreement itself, it is structured along different subject matter articles. So you have mitigation, NDCs, REDD+, all of these, and I'm sure you will have experts come to talk to you about specific aspects of each of these different parts of the Paris Agreement. But just as an exercise, the reason I wanted to show this to you is that if you have some time for fun, do open the Paris Agreement, go through each of these articles, and try and understand what are the should and what are the shall obligations for each of these subject matter articles in the Paris Agreement. So this is a fun exercise that I also often ask my students to do. So, and then you get an idea of what governments have to do and what they could do under the Paris Agreement, okay? And the other thing that the NDCs require parties to do is to make sure that there's a ratchet mechanism of extremely progressive ambition, and you also intend to have global peaking, ASAP, which is that all global emissions have to reach its highest point as soon as possible, so that we can reach zero in the second half of the century, as is in the name of the organization that we're all being supported by today. So the net zero in that name implies that we have to reach net zero in the second half. And where can you access these ambitious NDCs? So the UNFCCC Secretariat maintains the NDC registry, where you can see what are the targets that have been submitted by each country, whether they're being progressive over time. And based on the NDC that a government has submitted, it allows civil society to know what are the goals of their respective governments, and then to consequently, either hold its government accountable, or in, extremely serious cases, to use that NDC as a catalyst in order to enforce climate action, whether that's litigation. Okay, so it can prove to be a useful tool for civil society during climate litigation. And the speakers after me will give you possibly examples of how that has been done. Okay, so there's also a way to have compliance under Paris. Okay, and this is important from the perspective of civil society because it shows how other countries or other international organizations are aware of the lack of implementation or compliance of a particular party. And it allows civil society to see whether or not their governments have already been held accountable, what was claimed in those proceedings, and then it allows them to witness how the expert and facilitative committee has addressed these questions. So under Article 15, there is a mechanism to facilitate the implementation of and promote compliance with the Paris Agreement. And it's all experts who are there, who serve in their personal capacity as an expert, and not they do not represent their countries in that committee. And their aim is to facilitate and function in a non-adversarial, non-punitive manner to help countries implement the Paris Agreement better, and to also ask questions in a way that promotes better compliance if there is. And usually they can initiate a consideration of issues under multiple situations, such as if a party has not communicated its NDC, for instance, or it hasn't participated in the facilitative multilateral consideration of progress that also takes place under the Paris Agreement. So in these situations, the Article 15 mechanism, which is the Paris Agreement Implementation and Compliance Committee, PAICC, as they have abbreviated themselves, they can consider the issues. And this allows civil society to dive deeper and to identify issues that these experts have considered. And this allows then to have a trickle-down effect towards domestic accountability mechanisms that may or may not be litigation. So the outputs of the compliance committee include engaging in dialogue with the party, assisting the party, that gives appropriate finance, technology, capacity building, etc. And this has trickle-down impacts then on civil society. If there is an identification that there needs to be more capacity building for civil society, that then has trickle-down effects as well. And then if you have, there needs to be an action plan that keeps people at the center of that action plan, then you might perhaps have a situation where parties call upon local participation to improve those action plans. So the compliance and implementation mechanism envisions an internal check on parties to the Paris Agreement that allows further interested parties such as civil society to maintain an external check as well. Okay. Now, one of the things that can happen, and this is extremely hypothetical, but there is no technical bar to it, is that if a party fails to prepare, communicate, or maintain successive NDCs, there could perhaps be an output that where there is another party who can file before the International Court of Justice, because at the end of the day, the Paris Agreement is still an international agreement. However, and this was something that was claimed by Brian J. Preston, that this could trigger ICJ jurisdiction if there is serious failure to communicate and maintain NDCs. But we have not seen that happen so far. And I personally do not see that happening anytime soon, because I personally think that the internal implementation and compliance mechanism has been designed to be quite strong. And I do not see it reaching or escalating to that level based on any behavior so far. The other thing is that the other litigation that has, and it's not litigation per se, but it is intervention by the court, where the UN General Assembly has sought an advisory opinion from the International Court of Justice in March 2023 on climate change. So this is also where the ICJ is involved currently with climate action. And I personally think that it would be very, very interesting to see what they do advise eventually, and what are the implications for the Paris Agreement's compliance in light of civil society, especially. Okay, one second. So in domestic jurisdiction, there's a really nice line by Dr. Sandrine Dubois, and she says that the Paris Agreement is a treaty for internal consumption. They're designed to penetrate national legal systems, the provisions, and their implementation makes it indispensable. And in design, it combines the international definition of a collective goal with these NDCs, the content, form, and scope, which is entirely up to the parties. And this could be perhaps analyzed as a weakness of the agreement, because it's not compulsory for everyone to have the same exact NDC, etc. But because it is so flexible, and because it has given parties complete flexibility to decide what their goals are, it has actually boosted climate litigation and allowed claimants to define effective legal strategies. Because it is so flexible and relevant to the local situation and culture, it has led to more people being extremely interested in their local NDC. So, and I personally agree with this. I do think that the way the Paris Agreement has been designed, it does seem to promote and boost climate litigation. And that's not just because of the Paris Agreement itself, but because of the excellent leadership being shown by civil society, plaintiffs and lawyers across the world. And so not just in Europe or North America, but across the world, we have very strong climate litigation leadership in environmental lawyers and plaintiffs as both. Okay, so this was the obligations under the Paris Agreement. And in summary, I just want to say that the litigation that you do at the local level depends heavily on evidence, as I mentioned. And the Paris Agreement provides the legal infrastructure requiring governments to measure, report, and verify the information on climate and climate action. Okay, So under Article 13, you have extremely clear obligations on what parties have to report in terms of greenhouse gas inventories, in terms of how they are making progress in achieving their NDC, what are their climate change impacts and how they are adapting. And developed country parties and developing country parties have different obligations as well. So especially with respect to financial and technology transfer and capacity building. And also they have to undergo technical expert review of the information that they submit. And they have to undergo facilitative multilateral consideration of progress. So because of these multiple steps and checks and balances that exist in the reporting of information, the evidence at the end of that process is solid, in my opinion, that can help allow civil society to be a watchdog and to use that information in holding governments accountable. Okay, and this is a quick summary of how the monitoring, review, and verification arrangements are transitioning right now. So as we move towards like a strong Paris Agreement regime, this is the transition of all the reporting that you can check. You can just pause the slide later and check it, okay? So this is for your reference only. Then there's also the biennial transparency report, which parties have to submit and which contains information on progress and GHGs and how it's supposed to be created. So the MPGs, which is the modalities, procedures, and guidelines of reporting, explain how the biennial transparency report is to be written. Okay, and there's also been a surge in domestic legislation. So because of what parties included in their NDCs, they enacted domestic law that led to implementation of the NDCs at the local level. So just a few examples, like Papua New Guinea, they have an act called the United Nations Paris Agreement Act of 2016, which has the force of law and is implemented under the Climate Change Management Act of 2015. Norway has the Climate Change Act of 2018 as well, that incorporates NDC into domestic law. And Peru's framework law on climate change also did the same in the context of Peru. So as soon as it transcends from international law to domestic law in this manner, it opens up all the avenues for traditional domestic litigation that are available to citizens. And so you see how the Paris Agreement has this spillover effect in domestic law and then allowing for domestic jurisdiction as well. Okay. Now, this was the Paris Agreement. Now, the second part is something I just want you to imagine in the context of the Rome Statute. So the Rome Statute of the International Criminal Court is currently under a lot of discussion because of the proposal by Stop Ecocide International and supported by multiple countries and organizations that the fifth crime under the International Criminal Court should be added, and that would be the crime of ecocide. Okay. So in June 2021, the expert panel commissioned by Stop Ecocide International released its draft definition for ecocide. And as an additional international crime, Article 8 ter. Okay. Ecocide meaning unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And how are these terms defined? Wanton acts, wanton means with reckless disregard for damage, which would be excessive in relation to the social and economic benefits anticipated. Environment, of course, means the earth, its biosphere, cryosphere, lithosphere, hydrosphere, and atmosphere, as well as outer space. Okay. So this is the definition of ecocide that is being proposed. Now, we don't know if this is the one that parties would debate or agree to, etc. So this is a definition that has come from civil society, led by experts. Okay, and if at all it were to ever be a crime, imagine that it were to be added to the Rome Statute, the way prosecution at the International Criminal Court works is that it is first referred to the office of the prosecutor, then he or she gains authorization from the pretrial chamber, then there is an initial investigation, then you ask for admissibility, whether this, the case is even admissible. And this is decided often at the pretrial chamber, sometimes at the trial chamber itself. Then you bring charges. Then parties may challenge the admissibility of that case in the first place, that, that the case is not admissible for hearing. Then there is a trial, and then there is a judgment. So you see, it's a very long process, and it depends very heavily on the first step, which is that the office of the prosecutor should take on the case in the first place. Okay, and there are several conditions that the OTP has to satisfy for them to take on the case. Okay, and a case cannot be admissible at the ICC if it can only be admissible if it is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable to genuinely carry out the investigation. So if a country is already investigating it or prosecuting it, the ICC cannot have jurisdiction unless they can prove that the state is unwilling or unable. Okay, and or if the case has been investigated by a state and the state has decided not to prosecute. And unless, of course, that decision was because of unwillingness or inability. And if the person concerned has already been tried for conduct, which is the subject of the complaint, by the court before. So you can't, have double jeopardy in that sense. And it has to have sufficient gravity, which is, again, a very open to interpretation phrase. And it can differ heavily as to what is sufficient gravity, both at the pretrial chamber as well as for the OTP themselves. So in this context, the procedure to amend the, Rome Statute is extremely tenuous, and the process of complaining to the OTP is also difficult. However, it has the potential to trigger universal criminal jurisdiction, which means that there are countries, say, for example, France and Germany, where prosecutors domestically can exercise universal criminal jurisdiction and prosecute those who are guilty of crimes under the International Criminal Court Statute, the Rome Statute. So perhaps if we were to have ecocide under the Rome Statute, it could lead to a lot of domestic jurisdictions having the ability to prosecute criminals for it, even domestically. So for example, France and Germany already have that. Okay, so this is one of the possible criminal litigation effects of the ecocide amendment that I foresee, and which could have significant impacts for climate litigation. Okay, so that's all from me. I just wanted to leave you with these thoughts, and I'm happy to have any questions if you have any.
Thank you so much, Mrinalini. That was so interesting and such a great summary of what is an incredibly technical area. So thank you for walking us through that. We really appreciate it. We have a few questions for you. And as always, if you have any more questions, we can collate them and see if Mrinalini might have some time in the coming weeks to answer them offline. The first question is, does the Paris Agreement define a competent jurisdiction for climate litigation?
No, it does not.
Okay, thanks. And yeah, straightforward. Another question is that you briefly touched on how domestic legislation as a result of NDCs can open up pathways for climate litigation. And so the question is, how can we close the gap between the submission of NDCs and actually getting that into domestic legislation?
No, that's a very good point. And I think that is the million-dollar question, right? So for civil society to succeed in climate litigation, they have to be, able to prove that there have been international law obligations created under the NDCs that their governments are not, say, necessarily satisfying or fulfilling. And depending on the laws of that country, there might be litigation avenues available. So when a country does not satisfy its international law obligations, the domestic law will decide whether or not civil society has the option to hold their government accountable for the lack of following through on its international obligations. The other option is that if you see the NDC and you see that the action on the ground is not corresponding with what the NDC is saying, if very strong expert advice can possibly, then help civil society claim that the goals in the NDC itself are not enough, so that the ambition in the goals need to be increased. So that is what would require environmental lawyers to work very closely with environmental scientists, meteorologists, climate scientists. And I think some of the best environmental litigation work has seen this kind of collaboration that sees lawyers working together with so many different scientists to come up with the claims. So I think the part of the fact that we're having this training program, for instance, is a very good step towards that direction, where you have multiple people with different backgrounds coming together to learn about climate change together, because everyone's scientific expertise goes into making a good draft initially, if you're going to have strong climate change claims.
Agreed. Thank you so much, Mrinalini. Unfortunately, we're running a little bit short on time, so I'll leave the other questions if you might have the capacity to answer them by writing in the coming weeks, but really, really appreciate your interventions. And just to say on that last point, we actually have a center, the Oxford Sustainable Law Program here, where we have, as exactly just said, this interdisciplinary center where climate scientists and lawyers are working together on supporting litigation. So if anyone is interested in that, there's a lot of work going on that in Oxford here. So thank you so much again for such a fascinating presentation and for your time. We really appreciate it.
It was my pleasure. Thank you so much for having me. And I really enjoyed it. Thank you so much. And I wish you all the best.
Thank you. Really appreciate it. Great. So we're now excited to be, sorry, I'm just trying to hit the next slide. Oh. Well, if someone can hit the next slide, that would be fantastic, because we're now really excited to hear from two incredible organisers who are making a very clear link between the human health impacts of climate change and the criminal liability of the companies that are causing these harms. So we're excited to hear from, oh, fantastic. Thank you. We're excited to hear from Ken Heshaw, who's the Executive Director of We the People Nigeria, which is a non-governmental organization based in the Niger Delta cities of Port Harcourt and Calabar. In the last 17 years, Ken has worked closely with communities in the Niger Delta, especially in those communities where oil and gas have been extracted for decades, with devastating environmental, health, and social consequences. His engagements in these communities have mainly focused on ensuring that decades of environmental pollution are cleaned up, that the human rights of the people that are respected and protected, and that community livelihoods lost to pollution are restored, and of course, to mitigate the rising effects of climate change. Ken is passionate about increasing community voice and strengthening community agency. We're also very grateful to welcome Dr. Rhiannon Osborne, who's a doctor, an organizer, and a researcher focused on health justice as a tool for radical organizing. Rhiannon works collectively on health and climate justice, in particular extractivism, reimagining health systems, and access to medicines. She wears many hats, and I'm not quite sure how she managed to do so much organizing while going to medical school, but she is here today to speak to us in her capacity as the co-founder of the People's Health Hearing, which is a global forum for testimony, deep listening, and radical reparative justice for communities at the front line of extractive industries. And they're both here today to talk to us about the People's Health Tribunal of Shell and Total. So thank you so much both for being with us. Really appreciate your time. And as always, sorry, you can use the Mentimeter, the same code, to ask them questions throughout the session. Thank you so much.
Okay, should I start sharing my screen? Okay, give me a minute. Okay, so hi everyone, and welcome. Ken and I are going to be talking today about a project called the People's Health Tribunal of Shell and Total, and that project is part of the People's Health Hearing Collective, which Ken and I are both part of. So the People's Health Hearing Collective is a collective that emerged in 2021 in an attempt to disrupt the mainstream climate narratives by highlighting the root causes of the climate crisis in colonialism, racial capitalism, and extractivism. And in particular, we wanted to focus on frontline communities facing extractivism, dismantling colonial knowledge hierarchies, and collectively visioning for reparative justice. So the aim of the collective is to bear witness to the collective health impacts of extractive industries and the climate crisis, and provide a space to connect different struggles and set out a vision for transformative health and climate justice. So our focus is on organising towards accountability and reparative justice for the health harms of extractivism. Our first hearing was in 2021 at COP26 and was a global system indictment of the colonial system of extractivism. And then our second project has been this specific targeting of Shell and Total's activities in Africa. The collective is global. We have UK-based organisers, obviously Nigeria-based organisers, and comrades from Ecuador, Colombia, Uganda, so-called Canada, and elsewhere. And one of the main aims of the collective is building solidarity and deepening relationships as a means for organising for reparative justice. So the collective is focused on health, but this is through like a very radical and ecological understanding of health. So not limited to kind of the biomedical model of disease, but understanding health as the embodiment of systems and as a reflection also of the health of territories, and trying to reclaim health as a tool for anti-extractivist struggle. So our collective focuses actually not so much on like emissions and the climate crisis, but on its root causes. So focusing on extractivism and the systems of oppression that drive it, such as colonialism, capitalism, and white supremacy. So I wouldn't say that we focus on climate litigation. I guess it depends how you define climate litigation, but demanding accountability for extractivism as the root cause of the climate crisis, rather than focusing on emissions. We work through a frame of reparative justice, which means not only repairing the harms of, say, like an oil spill, but it means making sure that those harms are not going to be repeated by addressing the root cause of those harms. And so we explicitly reject attempts to address the climate crisis by continuing green extractivism, and that includes false solutions such as net zero and green growth. So I would really recommend that the Institute does a rename or like rethinks the use of the word net zero, because we recognize these strategies as a continuation of colonialism and extractivism, and they won't deliver health or climate justice. And just to acknowledge specifically here that this, the intersection between the health of people and the health of territories has a very deep lineage, and we've all come from different spaces, and kind of the decades of work that have already gone, if not centuries of work that have gone into understanding this intersection. And what you can see on the screen is an example of body territory mapping, which is a practice that comes in particular from Indigenous women in Latin America. And what you can see on the screen is the work of Damien Ferzanassi and Erica Ortega at the Institute Socioambiental Salud in Argentina, as an example of kind of the people that we draw on and have kind of come from to the collective. So this is a mural from the tribunal. So the People's Health Tribunal of Shell and Total aim to build on a really long tradition of people's tribunals. So people's tribunals are an extra legal, so an outside of the formal legal system, movement building strategy that have been done by movements for decades, centuries, when the courts and the existing legal system, as they often do, protect states, protect corporations, and protect colonialism rather than protecting communities. And it recognizes that often the courts are actually set up to do that. So for example, if we look at the investor-state dispute settlements and how those are, there's a global law set up to protect the profits of corporations. And so people's tribunals are an alternative space to demand justice outside of that system. So they're a way to gather evidence, build political consciousness, deepen solidarity, strengthen campaigns. They're really importantly a space for communities to give testimony and tell stories on their own terms, not the very rigid terms placed by the legal system, which are often really difficult to meet, but also don't recognize different cosmologies of justice and relationships with the land outside of the kind of capitalist legal system. They're also a space to reimagine what reparative justice is, which is a quite different concept from things that you can get often within the legal system, which is, for example, like compensation, which is quite different for a holistic reparative justice, which would include huge amounts of compensation, but it means going beyond that to ask what would it mean to repair the health of the people and the health of the land. And so the forum and the collective recognizes not only health impacts such as cancer from extractive industries, but also the health impacts of spiritual losses, of the community's relationship to the land. And finally, on this point, there's a lot more that we could say, but one of the key things about people's tribunals is to try and subvert who is seen as legitimate. So rather than placing legitimacy in people in power, they place legitimacy with people as the collective deciders of justice and reparative justice. So for example, the judges in our tribunal were not selected by legal background, but as movement leaders, elders, and people from the communities. And so just to finish up, I will post this in the chat, but this is some sections from the verdict, and Ken is going to go into more detail about the specific case of the Niger Delta and how it relates to the verdict. So we came together over 2 weeks to hear testimonies against Shell and Total from 4 different communities in Uganda, Nigeria, South Africa, and Mozambique. And what came out of that is many things, including the verdict, which sets out a vision for reparative justice based on the demands of those communities. And we can use that as a campaigning tool moving forward to try and bring some of those demands to life. And I wanted to flag 2 final things here, which is that this is in dialogue with the formal legal system, whilst also being outside of it. So for example, in this, we're attempting to use and push definitions such as genocide and ecocide. So for example, under international law, genocide requires proving of intent, which can make it quite hard to indict corporations. And so we've been kind of, in the verdict, we push an accusation of genocide towards Shell and Total and kind of push that definition. And then the final thing to say is that health, whether it's outside of the legal system in people's tribunals or within the formal legal system in cases against extractivism, can be a really important tool for litigation. And it is an area that corporations will fight really hard to try and stop it being proved that their operations are, for example, causing cancer. And they will use things like blame it on the genetic risks of the marginalized population, for example, that they're impacting, or blame it on, say, the behaviors of the indigenous community that they're impacting. So health is a really contentious area, both within and outside the legal system, that we can use to demand justice. And I'll pass over to Ken to go into more detail.
Thank you so much, Rhi. Thank you for that excellent opening. So by now you should have come to understand that the People's Health Tribunal wasn't certainly a real court. It wasn't a real court. It didn't have real judges and didn't have the formal court processes, right? But despite that, the cases that we heard all through the 2 weeks of the People's Health Tribunal were real cases. The stories we heard were impactful. They were scary, real scary stories. So it was a court, in a sense. It was a court of public opinion, and it was a court appealing to human conscience. The fact is that for several of the individuals and communities who presented those cases over that 2 weeks period, right? The People's Health Tribunal was the only opportunities that they have ever had to narrate their plight, to tell their stories to an audience, talk less of a global audience, right? So it was an opportunity for people to vent, to also seek clarity, and to also, cry, literally. It wasn't a real court, but it had, the cases we heard were real cases, and they were equally passionate. Next slide, please. And so the story I'm going to tell you today, the presentation today, is going to be taken from just one of the case studies, which is the trial of Shell and Total in Nigeria, and specifically the Niger Delta of Nigeria. And it's a compelling story, and it's probably a story you've heard before, because the Niger Delta has become the poster child for some of the worst scenarios related to oil extraction. So in 1938, Nigeria became an oil, became literally an oil colony when still under British colonial rule. The British government at the time gave a license to a company called Shell de Acre, the company you call Shell today. They were literally given a license to explore for crude oil anywhere in Nigeria. And this was done without seeking the free, the prior, and informed consent of the indigenous people who lived there. So from the very first start, oil extraction in the territory today called Nigeria was an incursion on the rights of the people. It was not a development that the people welcomed. People were literally forced by the might of British authority to accept oil extraction. It was an imposition from the start. From 1958, Nigeria has become a leading oil exporting country. At some point, Nigeria exported up to 2.6 million barrels of crude oil every single day. And because the consent of the people was not sought, the Niger Delta region is literally an occupied region, occupied by a lethal, fusion between the Nigerian state and its military might and oil companies, and that continues till today. Next slide, Ray. So interestingly, the impacts of this fusion have been devastating for the people. While oil companies, and I talk about Shell, Total, ExxonMobil, and all that, have made tremendous profits from oil extraction in the Niger Delta region, the area has actually become poorer for it. In Shell, in 2022, for example, right, Shell declared that it had made profits in excess of $40 billion from oil extraction. A good chunk of that comes definitely from the Niger Delta area. Ironically, in that same year, 2012, the Niger Delta became the poorest region in Nigeria and probably the poorest region in the entire world. So the more profits are extracted from the lands, the rivers, and the swamps of the Niger Delta region, the more the people go into penury. And that's the reality of oil extraction in the Niger Delta region. Next slide, Ring. Another thing that's important for us to talk about here is the fact that oil extraction in the region has happened with impunity. And it's important to reel this out so you understand that it's impossible. It's important for us as the People's Health Tribunal to always situate this conversation around the root causes of climate change. It is this extraction, it is oil extraction and extractivism driven by capitalism that has led to the global climate crisis today. And we go for the root cause of the problem, which is extraction. And something else we're trying to say here is that beyond the climate impacts of oil extraction, there are people who suffer an additional layer of the impacts of extractivism, right? And those are communities where oil is extracted from. And so in the Niger Delta, for example, oil has been extracted with the most reckless impunity. There are 7,000 kilometers of oil and gas pipelines, and they are buried beneath the swamps, the rivers, and the creeks of the Niger Delta. And as routine as clockwork, and in fact, some of these pipes are as old as 40 years, having been installed many decades back. As routine as clockwork, these pipes rupture and spill oil into the rivers, the swamps. And the people in the Delta are predominantly fisher folks and farmers. And it takes one single drop of crude oil can poison 50 liters of water, right? And millions of barrels of crude oil have been spilled into the land and the rivers, and the impacts are devastating. Fishes die and float, lands become unproductive, people go immediately into starvation. Next slide, Ray. And this is an image which we derive from Amnesty International. This is a figure from Amnesty International's research. It shows the number of oil spills that occurred in the Niger Delta region in the 6-year period between 2011 and 2017. Every single red dot you see on that map now is an oil spill that occurred in this 6-year period. Massive oil spill in this 6-year period. What you see there are indicators of oil spills all over the Niger Delta region. And so it begs the question, if anything, any kind of aquatic life, any kind of livelihoods can actually survive in a place as devastated as this. Next slide, Ray. So again, extracting with impunity. For 6 decades, since Shell, Total, and their partners began oil extraction in the Niger Delta region, they took a decision to flare gas. That's not 5 decades, it should be 6 decades. They took a decision to flare gas. And even when the Nigerian state, since 1979, has declared the flaring of associated gas as illegal, these companies continue to routinely flare gas, and they flare gas up till today. And the impacts of gas flaring are devastating. They are known to cause cancers, diseases of the epidemics, respiratory illnesses, and so on, basically destroying the health of the people. Next slide, Ring. On account of the activities of oil extraction, Niger Delta has become, a poster child for devastation, really, right? The life expectancy in Nigeria is probably the lowest life expectancy in the world. It stands at 54 years. In the Niger Delta region, on account of hydrocarbon extraction, the life expectancy has dropped to 41. So in the Niger Delta, if you have lived up to the age of 41, it's considered that you have done pretty well, having lived up to 41. And this is on account of the impact created by oil extraction. It has also seriously impacted reproductive health in the region. So I read a research recently where a researcher took studies from health centers, maternity homes across the Niger Delta region, and compared the same data to maternity homes elsewhere in Nigeria where gas flaring and hydrocarbon pollution doesn't take place. And the findings were very revealing. The findings show that women in the Niger Delta were far, far, far more prone to have miscarriages. They were far, far more prone to have stillbirth. They were far more prone to give birth to deformed babies, and so on and so forth. So it showed very serious reproductive disasters, in the Niger Delta region. And we have cases of a sharp rise in cases of women going into menopause. So there are ladies as young as 26 years old, as young as 30, 25, who have already gone into menopause. And this is a direct relationship between extraction and the health of the people of the Niger Delta region, right? And this continues routinely. Majority of people in the Niger Delta, live with different levels of respiratory illnesses. We have a predominance of cancer, respiratory sicknesses, and in a particular community I visited to do a research, I encountered 5 different traditional rulers in a place where oil extraction and gas flaring is very high, and they were all blind. And it was the traditional rulers, who traced their blindness to exposure to gas, the flare from gases. They traced it. They told us that, hey, this is causing us blindness. And this is the reality of oil extraction in the Niger Delta region. Next slide, please. And on account of oil extraction, ladies and gentlemen, on account of oil extraction, I told you earlier that it's a fusion between a very repressive Nigerian state and a very abusive corporate companies like Shell and Total. And they have formed a very delicate fusion that aims to repress the people and take as much resources as possible, right? And so on account of that, military abuses have become normal and routine in communities of the Niger Delta region. So while these companies describe themselves as guest communities and describe oil producing communities as host communities, we argue that this is not the attitude of people who host. The Niger Delta people never welcome them in to host those facilities there. If you go to any oil installation in the Niger Delta, the first thing you see is a military outpost, armed military personnel with submachine guns mounted on a hill overlooking the community. This is how oil extraction happens everywhere in the Niger Delta. And they have these machine guns pointed at the communities who own the resources, from whose river and whose lands crude oil is extracted from. And so these communities are, they are kept perpetually away from being able to, express any kind of dissent. Protests are repressed, and on several occasions, the united might of corporate greed and the Nigerian state have repressed several environmental activists. I'm pretty sure that you've heard about the Ogoni incident, where the leader of that environmental movement, Ken Saro-Wiwa, was murdered alongside 8 other Ogoni leaders. Thousands of Ogoni people were also murdered. Thousands were sent into exile, and some are still in exile up till today. And that's the impact of oil extraction. But even before Ogoni land, there was Umo-Echem community, a quiet community in Rivers State in the Niger Delta, where Shell has extracted crude oil from for the last, 60 years also. The people made a demand after 30 years of oil extraction. They literally asked the company for greater benefits, right? Can you give us more schools? Can you pollute our environment any less? And the response of Shell and the Nigerian state was repressive. The military was called into that community, and a massacre was committed. And you can feel free to Google the Umo-Echem massacre. Over 100 persons were killed, and up till today, nobody, not the Nigerian state, not Shell, has been held accountable. It's the same thing with Ogoni. Up till today, no single person has been held accountable for the murder of Ken Saro-Wiwa, for the murder of over 1,000 Ogoni people. And it's everywhere in the Niger Delta region. I will not bother going into the experiences at Rumekbe or Udoda, where the exact same thing has happened. As routine as clockwork, the might of the Nigerian military is unleashed on the people of the Niger Delta region. And their only crime is that they have crude oil and that these companies are in their communities extracting crude oil. Next slide. And so, despite suffering all these impacts, the health impacts, the environmental impacts, and all that, communities in the Niger Delta still suffer, double jeopardy, like the lawyers will say. They still suffer the impacts of climate change. The Niger Delta has become one of the most intense parts of the world, very susceptible to the impacts of climate change. The picture you see was taken in last year, 2022. And since 2012, this is what has happened in most parts of the Niger Delta region, where floods come and take over whole communities for over 3 months. So in this period, people lose their livelihoods. In this period, the people have got to migrate and go elsewhere. In this period, Niger Delta people become refugees. In this period, kids can no longer go to school. In this period, health centers are shut down. This is the reality that the people have to live with. They lose livelihoods, they become migrants, they suffer health challenges, and all of this on account of climate change. And climate change is caused by extraction, part of which happens, ironically, in their own domain and in their own environment. Next slide, please. And so, as I coast down and conclude, it's important to say that because of the relationship between the Nigerian state and oil companies, it's been very, very difficult for communities to litigate, to get justice even when they go to the Nigerian courts, right? It's difficult in post-colonial countries such as Nigeria, where oil companies are as powerful as governments themselves. And oil companies have the backing of governments in Europe and America. It's very difficult to get justice when oil companies are in a deadly mix of corporate profiteering and state repression. Justice is difficult. Historically, it has been impossible for impacted communities to get justice from our national courts. And in Nigeria, the oil companies are just too connected and they are too powerful for communities without voices, without power, without resources, without international connection and networks to get justice. Despite the court judgment. So I'll tell you one instance where it was impossible, literally impossible to get judgment. Gas flaring, the community in Nigeria took Shell to court and asked the court to interpret whether gas flaring was not an infringement on the right to life. The court sat, and for the first time in a very long time, the court did something that was out of tandem with normal court practices in Nigeria. The court declared that yes, indeed, gas flaring by Shell in the Niger Delta was an infringement on the right to life, and it ordered Shell to produce a blueprint for how to stop gas flaring. When the set date had reached for the community to come and hear the final judgment, as it got to the court, Shell was not in court. The Nigerian government was not in court. the judge had been transferred and the case file had gotten lost. This is a real case. It happened in 2005. And this is how powerful these oil companies are. Up till today, in that community that took the government to court, that took Shell to court, gas flaring continues up till this very day. And so the People's Health Tribunal was not a real court, but it was an alternative people-propelled process to demand justice for victims. These were solidarity partners and victims of ecological devastation and the impact of extractivism all around the world, coming together to set up their own tribunal system in the absence of legal processes to seek redress. This was people taking action to reclaim their dignity and their own humanity. Through the People's Health Tribunal, through the way we were able to spread it, through the overwhelming participation of several communities across the world, through the evidence, the compelling evidence which different people gave, the People's Health Tribunal gained the needed legitimacy that makes it a powerful tool for advocacy. Now, through the action and advocacy of countless victims after the tribunal is making a case all over the Niger Delta region and elsewhere in the world for justice. So the verdict of the tribunal was not just a piece of paper. It was not just the ranting of a bunch of activists. It was a real propelling argument. It contains the blood and sweat, the anger, the frustration, and the vexation of countless communities across the world demanding justice. And today it is a tool being used across the world to mobilize, to drive advocacy, and to demand justice. And I think that this is a tool that can be very, very, very well replicated across communities who are fighting for climate justice. Thank you very much.
Thank you so much, Ken and Rhiannon, for that really incredible intervention. We all learned a lot, and actually I'm looking forward to you being able to see the recording afterwards, because as you just said, Ken, many people in the chat are saying, I want to organize a tribunal where I'm from. So I think there's so much learning to be shared here, and really appreciate you both taking the time to both explain the lens and the sort of philosophy of reparative justice and the approach that you're taking, and then diving into a very specific example. So thank you so much for your work and for your testimony. We really appreciate it. We've had a number of questions in the chat. The first one, just a short one, is just, if it's possible for people to get involved in this work, and what are the next steps and hopes for the tribunal from here?
I can answer that briefly. So at the moment, we're in a process of kind of strategizing and reflecting after the verdict about what we want to do next. But there's going to be two broad strands. One focusing on kind of community building and community consciousness. So supporting people to host tribunals in their communities, supporting people to do screenings of the tribunal. So to watch it together, develop political consciousness, discuss how it relates to their own context. And then the second will be campaigning around some of the demands that are in the verdict. What I can do in terms of getting involved, there's a couple of social media things I recommend people follow for updates. But in the meantime, if there's anyone from a particular community who is interested in kind of doing either a tribunal for their own context, or one of the best ways I think to get involved is to do like a screening of the tribunal. So we can send you, like all the video materials, some workshop ideas in your community, and to like see how it relates to your struggle in your community, and do kind of political consciousness around that. And we would really love to support that. So I can put like maybe mine and Ken's emails in the chat, and if people would like to do a screening or would like advice on organizing a tribunal, we'd be really happy to support people. So I'll put some emails and some social media stuff. But I don't know if Ken, you wanted to add anything.
Well, I think you captured it appropriately. Yeah, there's several opportunities for people to replicate what we did, but also to join the ongoing process, right? So we've started something. It's a rolling stone. And we need the much support we can get. So whoever's interested, please get in touch with us.
Thank you so much. Another question from a participant is, I had read some months ago that people in Nigeria had sued Shell for oil spills, which affected their fish economy and generations of victims, and won. Any clarity on this?
Yes. So some communities have sued Shell, and so the reality is that there has been a new wave of litigations against the oil companies, but these litigations are not happening in the national space, right? They're happening outside Nigeria. Environmentalists in Nigeria found a backdoor around Nigeria's legal system. It was impossible to sue the oil companies in Nigeria and get any kind of justice. And so we found a way to go into the home territories of these oil companies and use their own legislations to sue there. That's the only way we could get justice, right? And so it's working out. But we don't feel comfortable that we need to go to Europe in order to hold companies who have abused our lands and our people accountable. We part of what we're doing is to craft strategies and find ways to make our own home governments accountable to the people and to make these companies accountable right here in Nigeria. It's not just, justice goes beyond just cleaning the environment, having them pay compensation and all that. Justice should also be empowering for the people. It should also strengthen our own democratic institution in Nigeria. At a situation where a person has a problem, his farm is devastated, we should be able to approach our own, local courts and get justice in the national courts. So far, that's not happening. We still rely on the court system outside Nigeria. And the next phase of our struggle is to hold those companies accountable right here in Nigeria.
Thank you so much for that update. Just time for one more question, which is, how can scientific and epidemiological knowledge change to be more inclusive and not reproduce oppressive systems?
Reid, you want to go or should I take that, right?
You go and then I'll come in if I think of anything else.
Oh, okay, so I'm not sure I understand all the terminologies. Unfortunately, I studied philosophy in the university, But just to say that scientific evidence has been used extensively in our struggles in the Niger Delta. One of the first times we were able to get real evidence of the impact of hydrocarbon pollution was when the United Nations Environment Program came into the Niger Delta and carried out an assessment of the impact of hydrocarbons on the rivers and the land in the Delta. Amongst other things, it said that there was benzene, a cancer-causing chemical, benzene in the water people drink 900 times above safe levels, right? And people still drink that water and still bathe in that water, right? The report also said that reclaiming the Niger Delta region ecologically will be the biggest environmental remediation exercise ever embarked upon by man, that it would take between 25 and 30 years to clean up the place, and it would take about $1 billion to do so. Okay, so this was an opportunity. This was one instance where we use scientific data in order to in the course of seeking for ecological justice. There have been several other reports, scientific assessments across the Niger Delta region, and we are using that in our struggles. Recently, there was, as recent as 5 months ago, there was a new assessment produced on one state in the Niger Delta that calculated the cost of cleaning up one state in the Niger Delta, and it said it to be about $12 billion just to clean up that mess, and literally said that every single person had been poisoned already by hydrocarbons. So we are using the tools of science, and it's working thus far. Over to you, Rhi.
Yeah, thanks so much. I think, as Ken said, you can use scientific data really strategically. And then I think then there are also kind of I think when it comes to medicine and, the history of science, understanding how deeply intertwined they are with colonialism and capitalism allows you to use them, analyze them and use them strategically. So for example, science and medicine can also be used against communities. So for example, there's the idea of safe levels of toxicity, which is a kind of oxymoron in itself. There's no safe level of a toxic substance, but you have corporations using scientific research to prove that a certain amount of toxicity is safe, for example. Or you have corporations in the US, for example, doing genetic analysis on Black communities and saying that that's why they have such high rates of cancer near the oil refinery, and using genetics to prove that it's not them. and then it also intersects as well with the privatization of health systems. So, for example, like our colleague Principal was talking about how it's really hard to prove the health impacts if you can't afford to go to the health system, which has been systematically privatized by like the World Bank and the IMF. So, and then you also have, so there's that, so you can use it strategically, but you also have to like be aware of the other side also using it strategically as well. And the second thing is like going beyond the kind of narrow biomedical. So the biomedical can be really useful, like cancer rates, all that kind of stuff, but also creating space for things like spiritual health and community health. And I think finally, one of the biggest problems in the climate change discourse and in public health discourse in particular is the idea that people don't know. So for example, in a lot of the social determinants of health, people argue, oh, if only we could prove, if we could show this company or we could show this state that this was doing all these bad health things. It's really common in the climate health discourse, say, oh, we'll show the UK government that climate change is bad for health, and then they will do something about it. And actually, without the political analysis of systems of oppression, understanding, well, maybe they don't care who it's going to impact. Maybe the problem is not that they don't know, but that they are willing to sacrifice people to corporate profit. So I think like there's lots of different layers, and it's just navigating it strategically and with an awareness of the political kind of constructs that are around all of these, like medicine in particular. Yeah.
Thank you so much. There's so many layers, and I really appreciate the examples that you brought in, because it helps really illuminate how closely, as you mentioned, how closely intertwined these are to colonial ideologies and histories. So thank you so much. Thank you both so much again for your time and for sharing your work with us. And Rhiannon, I also appreciate the challenge of the name of our institute, which is very much aligned with how we dismantle sort of the low integrity net zero. So yeah, really open to the challenge, and thank you for bringing it up. It's something that we've discussed a lot in our team. So with that, I'll hand over to Lydia to talk through a little crowdsourcing exercise that we have just before our break.
Thank you so much, Alexis, and thank you to our speakers. Those were two extremely informative presentations. So now we have the time to do something more interactive. And linking to what we just heard from our previous presentation, we now want to hear about from your experiences and your knowledge. So we prepared a QR code, and we want to know if you know of any campaigns linking health justice and climate justice. So go ahead, scan the QR code, and we would love to hear your voices. And while you're doing this, we will also have a short 5 minutes break. It's very well deserved. So get some sun and drink some water, and we'll be back in 5 minutes. And you will have the time to access the QR code during this time as well. Hey everyone, so welcome back. As usual, there's an attendance form that we invite you to fill out. This form for session 10 will remain active until the 19th of September. So go ahead, scan the form and register your attendance. So I would like to introduce you to our next speaker, Trina. So Trina is a climate activist, researcher, and law student. They're also founding co-chair of Fast Action on Climate to ensure intergenerational justice, or FACE intergenerational justice in short. It's a youth-created and youth-led initiative focusing on the intersection of climate and environmental justice, as it translates to fast action on climate mitigation strategies to preserve the planet for current and future generations. At FACE, they are leading a grassroots effort for a youth amicus submission before the Inter-American Court of Human Rights on its advisory opinion requests on the climate emergency and human rights. They are also a research associate at IGSD, where they research intergenerational climate justice and strategic climate litigation, and are part of Quiet 18's Global Youth Statement team. Trina is currently a Juris Doctor candidate at Vermont Law and Graduate School, where they are a board member of the Environmental Law Society, a senator for the Student Bar Association, and a member of the Environmental Justice Law Society. And today, Trina will be joined by Jose Daniel Rodriguez Orue. Jose is a young lawyer from Costa Rica with a background in international human rights law. He's a Latin American front convener for World's Youth for Climate Justice and a legal consultant for the Institute for Governance and Sustainable Development. He also worked for 5 years as a legal assistant for the Inter-American Court and has experience advocating for climate justice in Latin America and beyond. So they will give us a little bit of an overview of the Youth Amicus submission for the Inter-American Court of Human Rights Advisory Opinion request on the climate emergency and human rights, and call to action for those on the call to join the AO Let's Go campaign. Their research and experience, they will also talk a bit more about their research and experience on the role of young people in climate mitigation, and also talk about climate law and policies through their work with FACE Intergenerational Justice. So over to you, Trina.
Amazing. Thank you so much for that introduction, Lydia. I am about to share my screen to talk a little bit more about the advisory opinion movement. I'll also note that this will be in 4 languages, so we'll look a little bit tight. And if I have any mistakes with any of the translations, please let me know. So just to start, I'm going to do a quick overview on the Youth Amicus and what we're trying to do with this. But first, it starts with the background and the reasoning for this amicus. So we are organizing this Youth Amicus submission with young people all over the Americas, so North America, Latin America, the Caribbean, everywhere, to demand for intergenerational climate justice now for the Inter-American Court of Human Rights advisory opinion requesting the climate emergency and human rights. And this is a really powerful, unique, and exciting opportunity for us to meaningfully engage with the courts, urge courts to hold polluters accountable, and also to demand for climate justice now. So I'm just going to quickly go over what an advisory opinion even is, what an amicus is, what an Inter-American Court is. But advisory opinions are basically court analysis that interpret questions of law. It's often non-binding, but the Inter-American Court is actually really special because it is binding on several jurisdictions in Latin America, and also a lot more of an accessible way to engage with the advisory opinion. Right now, there is a global movement that's led by young people, particularly from the Pacific Island students fighting climate change and World Youth for Climate Justice, who are advancing advisory opinions to strengthen climate law and action in human rights courts, including at the International Court of Justice. Right now, the Inter-American Court is also accepting submissions to guide its advisory opinion, and the deadline is coming up next month on October 18th. An amicus is just a document that you can file that is for an outside party to file with a court that has a strong interest in the question being asked by the court, whether it's a case or, for example, an advisory opinion. With the Inter-American Court, any person or institution that's interested can write an amicus curiae brief. And this is just for us to be able to kind of clearly include what our priorities are in the human rights system in the Inter-American Court. And then the Inter-American Court of Human Rights It's a regional human rights tribunal that interprets and applies the American Convention on Human Rights, and has broad jurisdiction over parties to the American Convention and member states of the Organization of American States. And like I said before, the Inter-American Court advisory opinion is binding on several countries, including Argentina, Brazil, Chile, Colombia, Costa Rica, and Mexico. So just as a quick background on the climate emergency, we are seeing that climate change is a threat multiplier and there are unequally distributed impacts. It's both an environmental threat and an unprecedented escalating human rights emergency. And we're seeing extreme climate impacts even at just 1.2 degrees. And beyond 1.5 degrees of warming, we could push the Earth to a hothouse state that could be irreversible. So if immediate measures are not taken to slow down warming, we could pass the 1.5 degree limit by 2030 and perhaps even earlier. So we need urgent climate action now. Climate change is a fast-moving problem that cannot be solved with slow-moving solutions. Climate solutions have to understand the temporal element, or time. So we have to consider immediate harms caused by flooding and droughts, for example. We have to consider future harms from inaction and delay, such as sea level rise or triggering other climate tipping points. And we have to also consider intergenerational harm, the irreversible warming, the loss of biodiversity, hothouse Earth. So I also want to highlight the strength of the youth climate movement and how everything is kind of coming together right now with especially our asks and demands before the Inter-American Court and also the International Court of Justice. So we have been historically excluded from decision-making processes that impact us and our future. But despite this, we have been some of the strongest voices advocating for fast action now to address the climate emergency. So meaningfully engaging young people can ensure the sustainability and equity of solutions for current and future generations. We are the last generation that can do something now to prevent going beyond 1.5 degrees and keep the planet livable for current and future generations. I'll also quickly note here, 1.5 is not a goal. It is the absolute maximum limit that is allowable for human rights. But even at 1.2, we're seeing severe human rights violations. Even with this in mind, current policies, we are not acting fast enough to meet this climate emergency, as climate commitments are voluntary, action plans are undefined, and we continue to reach 1.5 degrees. So failing to act quickly on the climate emergency violates the principle of intergenerational equity and breaches international, regional, and domestic law. Intergenerational climate justice means ensuring a healthy, clean, and sustainable planet for current and future generations while recognizing and redressing the unequal distribution of climate impacts. To ensure intergenerational planetary stability, this requires slowing down warming in the near term to avoid triggering irreversible tipping points that are expected beyond 1.5 degrees. And within this process, intergenerational climate justice also means listening to all young youth voices and incorporating our demands into decision-making processes regarding our shared future. Climate justice is centered in all forms of justice and must be recognized as such. I'll kind of quickly go through the demands, but I also want to leave enough time at the end for questions. So I'll definitely be sharing these slides if anyone has any further questions. But we have kind of 5 main demands that, or types of demands that we're making. First is foundation. We need a strong legal foundation that directly protects the principle of intergenerational justice that includes present and future generations. A lot of times the right to intergenerational justice is comprised of its component parts. So this includes the right to life, the right to health, the right to private and family life, the right to equal protection, the right to self-determination, the right to information and participation, the right to an effective legal remedy, and sometimes the right to a healthy environment depending on the jurisdiction. We also need representation. Young people remain tokenized or an afterthought or underrepresented in decisions regarding our future. We need a judicial system that is built to address intergenerational justice and actually represent young people. We also need implementation. Even when there are favorable judgments for young people in climate change cases or commitments, there's a gap in the execution of rulings and commitments that disregards the urgency of needing to act on climate. And even country commitments at the national and international level, for example, the NDCs as part of the Paris Agreement, do not effectively protect us for now or in the future, and the global emissions gap remains high. What we're demanding is that we need actual enforcement and implementation of climate commitments and ambitious mitigation right now. Number 4 is protection. Activism is a key part of young climate activists to actually be heard and taken seriously in these global negotiations, especially when we're talking about climate action. However, we're being charged with coercion, trespassing, other criminal offenses, or even facing violence. So governments must ensure that climate activists and environmental defenders are protected as we demand for ambitious climate action. This also means calling out polluters that are also funding for the violence and harassment of environmental defenders in a lot of vulnerable areas. The last thing is mitigation. We are calling for a fast-acting climate mitigation strategy. When we say fast, we don't mean not centering justice in our actions, but because justice requires that we reduce warming now. This includes quickly cutting emissions of super climate pollutants that can kind of buy us time by avoiding at least 0.6 degrees Celsius warming by 2050, working towards longer-term decarbonization goals, and other fast-acting and justice-centered strategies, including but not limited to protecting carbon sinks and land rights, building adaptation and resilience, and focusing on planetary stability. States are obligated to ensure the fundamental rights of youth to a clean, healthy, safe, and stable environment and climate system for present and future generations. And states are obligated to act quickly on climate solutions in a climate emergency. So there's lots of ways that you can join our movement. These are some of the demands that I had just laid out of what we're bringing in, but I want to hear from all of you guys as well. This is not just representative of a few, but this is also representative of young people all over the world. So even if you are not in the Americas, there are still ways to participate and join this larger movement. First is to fill out our survey. You can share your demands for intergenerational justice. I will share the links as well, but this is a really important way for us to hear what are all the demands and priorities that we should have when we're going to a court and telling them what we see as the path to planetary stability and climate justice. The second is sharing your stories. We want this to be part of a larger social media campaign beyond just the Inter-American Court, but highlighting how young people are affected in so many different ways by climate change, but also kind of finding that similar connection as well in the stories that we're sharing and seeing what is similar and what is kind of something that we can all be a part of together in the path to, climate optimism as well. So I invite you all to share your stories. Some of them will be submitted in the Youth Amicus, but the rest will also, we're going to be posting all of these stories because I think they all deserve to be heard. We also hosted a webinar that talked a little bit more about the science and the law behind the amicus. We have the recordings in English and in Spanish as well, and the presentation links. And then a couple other things is to join one of our upcoming actions. So please follow us on Instagram and Threads for more details. We'll be definitely keeping you posted. And if you'll be at, Climate Week in New York City or COI or COP, please feel free to reach out. And the other thing is endorse the amicus. We want this to be indicative of a larger, broader youth movement that, knows what we need to do and that demands to be listened to by the courts. So if your organization is interested in joining our movement, endorsing the amicus, sharing kind of resources, connecting us, all of these different ways to participate, please reach out to me. I have my email here, and I'll also share it in the chat. And I also just want to give a shout out to all of the supporters that we currently have. And this number just continues to grow. And I'm really, really excited about how large this movement has gone. And this is just for the Inter-American Court. You know, the International Court of Justice and other courts perhaps are going to be having similar movements, and we're all going to continue to be united. So I'll kind of stop sharing my screen really quick to pass off the mic to one of my colleagues, Jose, who is the Latin America Front Convener for the World's Youth for Climate Justice. And I'm going to turn off my background.
Okay, speak in Spanish.
Sorry, I'm really sorry, but actually, Jose, if it's possible to speak in English, just because the YouTube channel won't be able to capture your translation. Thank you so much.
Okay, no. Thank you so much, Lydia and Trina, for the kind introduction and invitation. I represent the World's Youth for Climate Justice, which is a global youth movement that's campaigning for an advisory opinion from the world's highest court on climate change. So it's the International Court of Justice. On March of this year, a UN resolution asked the court to clarify the law on what states have to do to protect the climate system from harm in benefit of present and future generations, and also the legal consequences of not preventing harm. So as a youth movement, we've been campaigning to get to the point that we are right now, where the questions are before the court. And we've launched a Youth Climate Justice Handbook, which essentially lays out the responses from civil society to the legal questions that have been presented to the International Court of Justice. And we're working together with states. And this is an important difference with the Inter-American Court, where we do not have direct access to the court to participate. So we have to go through states or through international organizations. So we're working with states, and we invite you to join us in this work. We're sending letters to the Ministries of Foreign Affairs to include youth perspectives in the written submissions before the International Court of Justice. And we also want to put young people in the hearings before the court. We will also have actions in the hearings of the Inter-American Court of Human Rights and in the International Court of Justice. We will also be present at COP this year. So it would be wonderful to connect with all of you. And if you're from Latin America, especially, I'm looking to broaden the team. If you're interested in engaging more closely with the process, please reach out at jose@wicj.org. I can put it in the chat. And that's it. I can also email you the Youth Climate Justice Handbook. So you also have it as a policy instrument that you can use to influence public policy at the national level. So yeah, thank you so much.
Yeah, thank you so much. And before we close, I just want to say, Ayo, let's go. There is so much that we can do with the climate justice movement. Young people can go to the courts. So this is a really exciting time, and we invite all of you to join us. So yeah, thank you all so much.
Thank you so much, Trina. Thank you, Jose, for your amazing presentations and for your passion for advocating for youth and leading this campaign for our future. It is truly very impressive and very inspiring to see how far you've come with your work. And certainly, it definitely also inspires us to take action and use litigation as a tool to fight for climate justice. And as you well said, 1.2 is already violating human rights. So all of you are attendees, you are invited to join their movement and also fill out their surveys to get your voices heard and share your stories with the OA Let's Go campaign. So we have a couple of questions for you. And so our first question is, what is the ICJ's role in climate litigation? Do they handle cases of communities versus polluters? And if yes, can we have an example for further reading?
Yeah, no, actually, so the International Court of Justice is the main legal tribunal of the United Nations. and as such, it only deals with disputes between states. So you wouldn't have a case, for example, of a community versus a state like you would have before the Inter-American Court of Human Rights. So the importance of this advisory opinion is the breadth and scope of the advisory jurisdiction of the International Court of Justice. It's the UN court, so it has a lot of political and legal legitimacy to clarify the law around climate change, and also hopefully to influence the COP's proceedings to have much more stronger legal standards to protect human rights. But yeah, there won't be lawsuits of communities versus states, which does occurs in the Inter-American Court of Human Rights.
Okay, thank you so much. And we have another question, which is, what are the main difficulties in making technical legal procedures and lexicon accessible to youth, and how do you overcome them?
Yeah, I mean, I think the question also includes it or the answer in its question too, the lexicon, the language, and also the financing, the lack of funding or the lack of ability to pay for a lawsuit that will take several years. Also, the language is often very inaccessible. So something that's really important when you're doing climate law work or anything, or policy work, or even science work, is to make sure that the language becomes more accessible. There's a lot of young youth organizations that are doing this right now. That's one of the main aims of FACE Intergenerational Justice as well, where we want to be able to explain climate science in a way that's relevant to the legal proceedings and lawsuits and things like that, but also something that isn't overly jargony and can still be accessible and understood by so many people. But beyond that, I mean, there are so many different other blocks for us to even demand for justice. We'll have to find the lawyers, the funding, as I said before. And yeah, it can be really hard. So I think having the advisory opinion, especially with the Inter-American Court, and hopefully the ICJ as well, we can kind of start to lay out what some of the solutions or remedies could be for how we can engage. Was there anything I missed or?
No, I just wanted to say like the importance of capacity building. We also do that at the World Suite for Climate Justice. Advisory opinions may be like a really abstract legal term that doesn't resonate with a lot of young people. But I think landing the message that this is a historic opportunity, like Trina mentioned before, to have stronger standards on climate change and human rights, and especially on youth. We have a lot of opportunity to influence that process, especially at the Inter-American Court of Human Rights.
Thank you so much. And again, thank you for joining us for today's session. And it is very inspiring to hear you speak. And to our attendees, please do get in touch with them. And I hope you the best of luck on your journey to continue this initiative. And yeah, thanks for your time and for being here, and just it's very great to hear from you.
Thank you so much.
All right, so as you can see, we have the attendance form blended in again. So please do remember to register your attendance. And the form will be active until 19th of September. And in addition to this, we have a message from the Youngo Human Rights Working Group, the contact point, who's also Lydia Manohar. And she invites the audience to fill the form to collect inputs on human rights issues in the MENA region. So if you have any questions, please email Lydia, and you can also see the form linked on the slide. So do submit your answers to the form and get your voices heard.
Thanks so much.
Over to you, Alexis.
Thank you so much, Lydia. And I actually can't turn on my camera, so I don't know if Fred might be able to turn on my camera from his side. Thank you so much. Great. So thank you so much for a really wonderful session. We really learned so much, and we had such a spread from the very technical sort of untangling of the UNFCCC and what the Paris Agreement can do for climate litigation, to the very concrete examples that Rhiannon and Ken gave us from the People's Health Tribunal, and then that wonderful intervention from Trina and Jose about AO Let's Go and the power of youth. So thank you so much, everyone, to all of our speakers for being with us. And so for anyone who's interested in the People's Health Tribunal and running one in your own community, Rhiannon and Ken have shared their emails, and we'll send it in the follow-up email that we send usually tomorrow morning or tomorrow afternoon. So just a reminder that we always have those going out, and you have all the links and resources that are there, as well as the slides. And also we always have in between the weeks, so a week from today, we usually have an interactive session on Zoom. So we have a few people have been attending these very faithfully and have been showing up, but we'd love to see more folks coming. We send out the questions beforehand, about 3 questions, and then we move into breakout rooms and discuss it. And it will be based on today's content. So it will be 1 week today, and we'll send out more information by email. So thank you so much, everyone. And we're really excited for our session for next week. So next session, sorry, the 20th of September. We'll have a session that examines the intersection between gender and climate change, and looking at the disproportionate impact on women and girls. And it will kind of look at the architecture within the UNFCCC to give greater voice to these concerns. So we have 3 incredible experts who are going to be speaking to us, and we're really looking forward to their interventions. Just another reminder is that you have access to this amazing partnership with Terra.do, where we have not only the recordings and the resources from this course, but also additional recordings and lectures that have been offered to us from Terra, completely free. We've sent out an email about this a few times, but we'll send it again in tomorrow's email. But just a reminder that you'll lose access to Terra at the end of this course. So really take advantage of it. It's really cool that they've given us all of this material. So if you're curious about learning more, we've worked really hard with them to make sure this is available. So we want to make sure that people are using it. So please do. And then just another reminder is that we have Slack to be able to interact with one another. So you can definitely use that. And just a final reminder that we're really grateful to our funders and contributors. As you know, we run this course for free, but it is not free to run. So thank you so much to our generous funders. And it really helps us when you guys fill out the feedback form, for example, that we've sent via email, so that we can send that to our donors to show what we're doing and that this course is useful to people. So really appreciate your participation and grateful to our funders. And just the attendance form one last time so that you have it. Of course, as always, it will be open until just before the next session, so until the 19th of September. So make sure that you watch the recording or you fill your attendance in that time. And if you have any queries or problems with the attendance form, we know a few people have, please send us an email. We know we're a little bit behind, but trust me, we do read all of them. We just have a lot of participants on the course. So we really appreciate your patience and we will get to all of your queries. And just a final thank you from all of us, and hope you enjoy the rest of your weeks and the rest of your days or the evenings, wherever you are, and really appreciate you all being here for this training. So thank you so much and goodbye.